Hello and welcome to the LLG Grapevine podcast. You're listening to Helen, LLG's Executive Director of Policy and Governance, and I'm joined today by Dennis Hall, LLG's Bulletin Editor.
Hi, everyone.
Now then, Dennis, tempting as it is to get into the results of the general election last week, we're going to cover that in the vlog. So we'll take a look here at other matters in the news that are of interest to us. Although I understand your first item still has a link to the big news of last week, Dennis.
Well, yes, and not entirely away from the election with this first item. Electoral administrators have been calling for earlier postal vote deadlines as demand is overloading the system. Here's what they have to say. The current postal voting system should be reviewed and earlier deadlines for absent voting applications implemented amid a 20% increase in postal voting from the 2019 general election. So said the Association of Electoral Administrators. And the association warned that the short timescale for the election and high demand for postal votes has put pressure on the postal voting system. It said that more than 1.3 million people made postal vote applications between the 22nd of May and the 19th of June, and it is estimated that postal vote numbers will top 10 million in this election, a 20% increase from the 2019 general election. The association said election teams are doing their very best to run this snap election, but with a short timetable, plus print and delivery supplies working at capacity, demand is overloading the system. Printing postal votes is a complicated process. Personalised postal vote statements must be matched with the correct ballot paper, personalised envelopes and instruction sheets. Election teams also need to carry out security checks, adding to the time needed to prepare and send ballot papers out. And closing applications 16 working days before a poll, rather than the current 11, would increase capacity to process, print and post out ballot packs, and crucially give voters more time to post them back. The association also complained that the law on absent voting applications prevents returning officers from helping electors whose postal vote has not arrived. And to fix this, it called for emergency proxy provision to be expanded to include electors who have not received their postal vote. Now, as you know, Helen, Labour intends to look at election rules, including voter ID, and to reduce the voting age to 16. So let's see whether this issue comes under Labour's review as well. Helen.
Well, they'll have a lot they'll want to do, but will of course need to prioritise, but more in the vlog. Now, I want to take a look at the family court quarterly statistics released this year in terms of headline figures. So new figures published by the Ministry of Justice show that between January and March of this year, there were over 5 times the number of deprivation of liberty applications authorising the deprivation of a child's liberty in an unregulated secure placement compared to secure accommodation applications. There were also 2,022 applications under the Mental Capacity Act 2005 relating to deprivation of liberty, which is up 30% on the equivalent quarter last year, and it's the highest level in the time series. Orders increased by 40% in the last quarter compared to the same period last year. There were 6,510 individual children involved in new public law applications, which was down 1% compared to the same quarter in the previous year, while the number of applications made actually decreased by 2%. In the same period of time, care applications made up 70% of public law orders applied for. There were decreases in several case types compared to the same quarter in the previous year: matrimonial, domestic violence, and public law cases. At the same time, there have been increases in private law and financial remedy case starts. Over the same period, closed cases reaching a final disposal have decreased in public law at 18%, private law at 8%, and matrimonial at 8% of cases as well. However, there was an increase in domestic violence of 7% and financial remedy at 6%. Now, it's worth noting that since the Supreme Court clarified the definition of deprivation of liberty in 2014, there has been a significant increase in the number of applications. In terms of deprivation of liberty applications made to the High Court for children under the age of 18, almost all of these children were teenagers. 59%, in fact, were between the ages of 13 and 15, and 31% were aged between 16 and 18 years of age. Now, in other news, and something which has been rumbling for some time now, Dennis.
Well, yes, indeed. We've commented on this before, but the SRA have just announced that they will regulate legal executives, despite strong opposition from some in the Law Society. Let's take a closer look at this. The Solicitors Regulation Authority will push ahead with proposals to regulate legal executives, but there remain potential political and even legal hurdles to overcome. The organisation said last week that it was in the public interest to take on the regulation of Silex members and simplify the legal regulatory landscape. Any decision to proceed would be subject to approval from Silex, largely inevitable, given this was its initial idea, and then also approval is required from the Legal Services Board. But the SRA does acknowledge that the issue would still be unresolved even at that stage, as the Law Society Council would have to sign off rules which govern the current regulatory regime. And this could be a major stumbling block given the Society has been vocal in its opposition to the move. A further threat to the proposal would come from the existing regulator, Silex Regulation, which last week said it was extremely disappointed by the SRA stance and would consider legal action. And the SRA has issued a 19-page statement setting out why it should be allowed to regulate legal executives. It believes that such a change would make it easier for consumers to navigate the system, as well as increase efficiency within the profession. Currently, some 75% of Silex members already work in SRA-regulated firms, leading to duplication. And Anna Bradley, SRA chair, said the organisation had reflected long and hard on the potential risks and benefits and had taken account of the strong professional interests that are in play. All of the evidence shows that consistency and relative simplicity in regulation matters to the users of legal services, she said, and this change would result in a simpler system with more consistent levels of protection for consumers. There will also be, she says, efficiency benefits. However, Ian Jeffrey, Chief Executive of the Law Society, reiterated Chancery Lane's opposition to the move. He said, "We're deeply concerned that the SRA board has given the go-ahead to regulating Silex members, despite its own regulated community. And Silex members objecting to the idea of regulatory change, and the Legal Services Consumer Panel stating that the consumer case has not yet been made out." And for the last 2 years, the Law Society has advocated on behalf of our members, opposing the proposal and raising concerns of the serious nature and impact it will have on regulated communities, consumers of legal services, and the wider public interest. The change, Jeffrey said, will cause consumer confusion, as it will be less clear which profession is which and where different authorizations for practice areas apply. And this is likely to be a particular problem for those with complex legal issues or vulnerable consumers. Helen.
Well, we haven't heard the last of this, Dennis, and if our Silex members are concerned, I would ask them to reach out directly to LLG. Now, turning to the housing crisis, this is the news that council spending on homelessness has tripled in 8 years. Homelessness spending now accounts for 60% of councils' housing budgets. The LGA has warned. Councillor Claire Holland, who's the LGA's housing spokesperson, said that, quote, "The way to properly resolve the issue is to address the shortage of suitable housing across the country and build up council's stock of social housing. Councils need to be given the powers and resources to build affordable homes their communities need so that they can resume their historic role as a major builder of affordable homes." Now, according to the Big Issue, a record high of 113,000 households are currently in temporary accommodation, which means that councils are spending 1.75 billion annually. And both of those figures are due to rise in the future, the LGA has warned. The financial toll is limiting council spending on homelessness prevention and the ability to build social housing long term, which is also a view held by the LGA. Now, according to the report by Government Homelessness in England, October to December, end of private rented assured short-hold tenancy was the most common reason for households being owed a prevention duty, which accounts for about 37.3% of all households who are homeless. Now, this is an increase of 5.7% from the same quarter last year. There may have been a COVID effect, don't forget. The most common recorded reasons households were owed a prevention duty due to the end of an assured short-hold tenancy were related to the landlord wishing to sell the property, followed by the landlord wishing to re-let the property. A breakdown of households owed a prevention duty due to the end of an assured short-hold tenancy shows the biggest increase was due to rent arrears from an increase in rent. And despite the large relative increase, end of assured short-hold tenancy from rent arrears due to an increase in rent still only represent a relatively small number of households at about 400. The second most common reason for those owed a prevention duty was family or friends no longer willing or able to accommodate, which accounts for about 22.4%, and that's down from 12.8% from the same quarter last year. Other notable changes for households owed a prevention duty include an increase of 173% in requirement to leave accommodation provided by the Home Office as asylum support, and a decrease of 16.7% in other violence or harassment to 450 households. That was also a factor. Now then, Dennis, water quality is in the news, as we know, and also the accountability of water companies, I understand.
Well, yes, it is a matter of deep irony that the companies who are charged with responsibility for our water quality are amongst the worst polluters of our lakes, rivers, and watercourses. But now the Supreme Court has made a decision that is likely to turn the tide well and truly against them. Here's the detail on this. The operators of the historic waterway, the Manchester Ship Canal, can bring a private law claim against the local water utility over unauthorised discharges of sewage. So said 7 Supreme Court justices when they ruled unanimously on this last week. The decision in the Manchester Ship Canal Company against United Utilities Water Limited overturns High Court and Court of Appeal rulings that no such cause of action was available because of the provisions of the 1991 Water Industry Act, which privatised the sector. In a lead judgment, Lord Reid, President of the Supreme Court, accompanied by Lord Hodge, said the case raised the question whether the owners of watercourses or bodies of water can bring actions in nuisance or trespass in the event that the water is polluted by discharges of foul water from sewerage undertakers. United Utilities has some 100 outfalls from which foul water is designed to be discharged when the capacity of the system is exceeded. This could be avoided if United Utilities invested in improved infrastructure and treatment processes, the justices note. In the case itself, the company, which owns the 36-mile Victorian waterway, sought damages for nuisance and trespass. United Utilities applied for dismissal on the basis that it had inherited a pre-existing implied statutory power to discharge water and treated effluent into private watercourses without the owner's consent. But overturning the lower court's rulings in favour of the utility, the Supreme Court justices said that a common law remedy against nuisance survives the provisions of the 1991 Act, which contains no express ouster of all common law causes of action and remedies to protect the enjoyment of the property. If the discharges constitute a trespass, a matter, incidentally, on which the justices gave no specific view, United Utilities is the body responsible for the commission of that tort. If the discharges constitute a nuisance, that is something which United Utilities has caused or adopted, since its sewerage system is designed in a way that deliberately involves the discharge of effluent into the canal when the hydraulic capacity of the system is exceeded. Now, the Supreme Court's ruling could have very wide implications indeed. Emma Montlake, Joint Executive Director of the Environmental Law Foundation, which intervened in the case, said the outcome has the potential to be a game changer for communities up and down the land. Owners of waterways may now consider taking action against sewerage undertakers for polluting water, and it is very possible that we could now see an increase in this type of legal claim. As I said earlier, the tide has turned.
Yeah, and this is a really present issue for many and for the environment, and many commentators see waterways pollution as an absolute scandal. It's raised in Labour's manifesto. Let's see how they react moving forwards. Now, finally, for me, I want to look at a recent case, that of the father and Worcestershire County Council, where the Court of Appeal criticised a judge for her, quote, blatantly unfair conduct, finding that an interchange with a father demonstrated a, quote, complete failure of proper judicial process. So the facts of the case are as follows, and I've lifted some of this, well, the majority of this from the judgment, because actually it's really very clearly set out. So on the 9th of June of last year, following a hearing and a lengthy judgment, DJ Solomon, sitting in the family court at Worcester, made an order under section 31 subsection 1 of the Children Act 1989, placing the children with whom the case is concerned in the care of the county council, and she did so having found on the facts that the threshold in section 31 subsection 2 had been crossed. Now, the major element of this case relates to the way in which the hearing took place. So the order that was made is as follows. It is ordered that the children are placed in the care of Worcestershire County Council, and that order remained in force at the time of this hearing. Children were currently living with foster parents. The father, however, applied to the family division for an order of habeas corpus for the purpose of securing the return of the children to his care. And that application came before Judge Russell, sitting in the applications court in April 2024. And the judge gave no judgment, but a transcript of what took place was laid before the court here. So reading directly from the judgment, because it's so because it so clearly sets out both the facts and legal basis for the finding of lack of judicial process, I'll read as follows. Mrs. Justice Russell, good morning. I'm a bit hard of hearing. Mrs. Justice Russell, what is it you're asking me to do? The father, I'm asking for the writ of habeas corpus. Mrs. Justice Russell, you cannot have it. Mr. X, what? Mrs. Justice Russell, you cannot have it. It is an ill-conceived application. Mr. X, why is it ill-conceived? Mrs. Justice Russell, because it has no application in this case. The orders have been made lawfully. If you wish to deal with these orders, you appeal or you make other applications under the Children's Act. The writ of habeas corpus is hardly ever used anymore because there is statutory provision that you have to use it first. Mr. X, well, I've tried everything. Mrs. Justice Russell, no, you haven't appealed or tried to appeal. Mr. X, every appeal that I filed was turned down, my lady. Mrs. Justice Russell, well, doesn't that tell you something? You are not getting a writ of habeas corpus. It is inappropriate, it is wrong, it is not the correct process. Now then. Whilst the court in this case acknowledged that the applications court is often very busy and that judges who sit there are under considerable pressure to get through an overloaded list, for that reason, a judge may seek to drill down into the essentials of an application, and reasons for a decision one way or another may be brief. Nevertheless, a line must be drawn between a short and robust hearing and no effective hearing at all. The interchange I've just quoted, the court said, demonstrates a complete failure of proper judicial process. The judge had clearly made up her mind before the father had said anything, and the father was hardly allowed to say a word thereafter. The court also said that it's long been a fundamental principle of English law that justice must not only be done, but must be seen to be done. The court found that since the hearing was unfair, they had no real alternative but to set aside the judge's order. Now, I can certainly remember occasions at the very start of my career, and I recognise we're going some way back, where I was simply not afforded the ability to put forward a case in any meaningful way, and I would like to think that doesn't happen anymore, but clearly I've just read that it did. So litigators may well want to carry this case around with them in the unfortunate circumstance they ever find themselves in a difficult position. And on that note, you can read more on the items discussed today and many more besides by going to bulletin number 24, available on the LLG website now. So it's goodbye from me.
And from me too. Bye.